It looks like we kicked the cable on the way into the studio today.
Oh, no.
So we're sorry about that, but welcome again to the Ethics Fundamentals series. And my name is Patrick Shepard, and I'm pleased to be joined today by Cheryl Kane-Piasecki. Welcome, Cheryl.
I'm very glad to be here, Patrick.
And we'll repeat the one administrative announcement. And the one administrative announcement that we'd like to share with you today is that on or about September 8th, you will receive a survey of ethics officials. And we'd like to encourage everyone who receives that to take that opportunity to share with us your opinion of the services that you use from OGE, and to give us some ideas about how we can improve and what we're doing well. We do act upon your feedback, and we can only do that if you share it with us. So we'd encourage everyone who receives that to please take a few minutes to complete that.
Absolutely.
Excellent. So what are we going to be discussing today, Cheryl?
We're going to be discussing Subpart G of the Standards of Conduct, which deals with the misuse of position. And there are various and sundry ways that one can misuse their position. And so it's probably one of the longest of the subparts in the Standards of Conduct. I think it's an interesting subpart from the standpoint that it's implementing specifically articulated general principles that you find in the 14 Principles of Ethical Conduct, as well as articulated in Part 101 of the Standards of Conduct. But I think one of the other aspects to it that's interesting is these tend to be, I think, some of the most implicated of the Standards of Conduct when it comes to employees being disciplined or called out for misconduct. Right. And I think it's because these are the most obvious and observable of the types of misconduct that an employee can engage in.
I think also literally every federal employee is in a position to possibly contravene these provisions, right? Anyone who has an official position has the ability to misuse it for personal purposes, for other sort of outside purposes. And
particularly when you're talking about things like misusing your time, misusing government property. These are things that we all have access to, that we all are subject to. And so, yeah, it's a greater likelihood, and it's just simply a more observable way for employees to engage in misconduct. But I think one of the things that I want to emphasize today is these provisions may seem on their face to be obvious, but they can actually be quite tricky, because there is a certain element of subjectivity that goes into determining when is a use misuse.
That's right. And I think, when you look at the relationship between the 14 principles, those things seem to be very straightforward. But when we get to the particulars of drawing the line for the rule, it is a little more challenging.
It is. And one of the things that we're going to be covering today as we go through each of the various provisions of misuse of position are some of the legal advisories that OGE has issued over the past several years. And we made those available to you in a single document on the max.gov site, along with the slide deck. There are hyperlinks to each of the advisories that I'm going to be making reference to today. But I think what OGE has attempted to do in many of those advisories is to basically help articulate sort of the subtleties and some of the nuances that go into making determinations about whether or not someone has misused their title, for example. Right. So we're going to be covering, in some part, those different legal advisories to give you a flavor for where OGE is trying to build some degree of flexibility into what might otherwise appear to be very cut and dried or very black and white standards of conduct.
Excellent.
Okay, so let's get into the slide deck. We got a lot of territory to cover today because it's one of the longest provisions in the Standards of Conduct. So if we go down to the next slide.
Let's see if we can do that. There we go.
Okay. We're going to begin at the beginning because that's the best place to begin. So what I'd like everybody to do is to get into Subpart G of the Standards of Conduct and to look at 5 CFR section 2635-702, because I want us to read that beginning paragraph, because it's going to kind of set the tone for the presentation today. And if we look at 702, it talks about use of public office for private gain. So clearly it's talking about this. We all know this is one of the central core principles of ethical conduct. And 702 is an implementing provision for that. But let's read this quickly. It says, an employee shall not use his public office for his own private gain, for the endorsement of any product, service, or enterprise, or for the private gain of friends, relatives, or persons with whom the employee is affiliated in a non-governmental capacity, including nonprofit organizations of which the employee is an officer or member, persons with whom the employee has or seeks employment or business relations. So that's kind of spelling out kind of what you're going to find throughout the rest of Subpart G, are these specific illuminations of when you could use your public office for private gain.
I think of that as kind of the expanded principle.
It is the
right.
expanded
We have
principle.
the principle, don't use public office for private gain, and then we sort of explicate what we mean by private gain.
Exactly. And then in the next sentence, I think, is very telling, and I think people should not overlook this. The specific prohibitions set forth in paragraphs A through D, and we're going to go through each of those shortly, of this section apply this general standard, but are not intended to be exclusive or to limit the application of this section. What does that mean to you, Patrick?
So I think what this is saying is that the principle is primary. And while we have some specific guidance on applying the principle in specific circumstances, the fact that we have not provided specific guidance on every possible application of the principle does not undermine the scope of the principle or the applicability of the principle in all cases.
Exactly. And I think even sort of in addition to that is even where we have tried to create some sort of an illumination of what we think could be circumstances, if you have a situation that does not necessarily squarely fall within the four corners of that, does not mean that you may not still have a situation where the totality of the circumstances would indicate that the individual might be using their public office for private gain. So this is one of the reasons why on this slide I've given you 702, but I've also pointed you back to the general principle, which is at 101B7. And if we can have the next slide. And this is, I want to talk a little bit about this one case, and this is in the recent MSPB cases that is the first document in that list of documents we gave you in that one pager that I've given you for resource materials. And this is a relatively recent case. It was adjudicated in March of 2014. And here there was an SES official who was actually removed from her position as the director of an education activity at DoD because she was charged with misusing her government position for the private gain of her son's fiance. As the director of the education activity, she had basically tried to influence, shall we say, the decisions of the director of human resources, who along with her staff, was obviously doing the original vetting of all the candidates who were applying for the position that this SES official's son's fiance was applying for. And the reason I want to raise this is because the charge that was brought in this case was misuse of position for private gain. So it was the invocation of the general principle of misusing your government service for private gain. And what the administrative judge said was that the agency was required to establish that the appellant had misused her government position and that misuse actually resulted in a private gain. And they were able to establish that she had, in effect, tried to use her influence as director to influence the outcome. And it turned out that her son's fiance actually was awarded the position, was hired for the position. So my point here is that the agency did not have to look for a more explicit provision in Subpart G to bring a charge of misuse of public office for private gain. They merely invoked public office for private gain and were able to establish that a private gain had actually been provided or resulted from her actions. It's interesting, too, that in this case, the administrative judge also found that it was axiomatic that the prohibition in this case includes the private gain of others,
right,
connected to the employee and not just simply to the employee, him or herself.
Right.
So again, to reinforce that you can rely on the principle, you don't have to necessarily dig into the weeds if you have a situation where you think there is a misuse of public office for private gain.
Yeah, and I think that's an important point overall, that the standards of conduct help us to implement the 14 principles of public service.
Right.
They provide guidance on specific instances in which they might be implicated, but they don't supplant the need to continue to abide by those principles.
Exactly, exactly. So if I could have the next slide, please.
Sure.
Okay, so now we're going to jump into each of the separate provisions under 702. And the first one is at 702A. So if everybody wants to find 702A. Now, one thing you'll notice in the reg itself, at 702A, the title of this section is called Inducement or Coercion of Benefits. And I think that language is a little heavy-handed. I don't know about you, Patrick. And in the provision, it says an employee shall not use or permit the use of his government position or title or any authority associated with this public office in a manner that is intended to coerce or induce another person, including a subordinate, to provide any benefit, financial or otherwise, to himself or to friends, relatives, or persons with whom the employee is affiliated in a non-governmental capacity. Now, if you'll notice, the title to my slide is not inducement of or coercion of benefits. What's my title, Patrick?
Asking for favors or seeking benefits.
Yes. And I would submit that I think mine is a better description of what this provision is trying to get at. Because I think that when we think about an employee using their position in a way that would seek a benefit for themselves or for somebody else from a non-federal source, the very nature of the relationship between the government employee and the non-federal entity may be such that coercion is just implied.
Right.
So I don't think you have to have these egregious acts of coercion or inducement of, somebody strong-arming someone in order to be able to invoke 702A. So let's look at a couple of the questions that I came up with so we can sort of ferret out a little bit, like, how 702A might be implicated in some more subtle types of activities other than, strong-arming someone. So our first question here is, so would a government loan officer, would we have any problems with a government loan officer asking people whose loans he services to endorse him on LinkedIn? What do you think about that, Patrick?
I don't know. This gives me a little bit of pause.
Okay.
Because of the relationship between the loan officer and the person he's requesting this action from is one of authority, and it suggests the possibility that might be abusive in nature, even if it's not intended that way. That the person receiving the request might feel compelled or at least strongly encouraged to comply with the wishes of this person.
Exactly, and I think your instincts are right on the money, and this is exactly the kind of thing that I think we have to counsel employees about, is whenever you are in possession of a set of authorities over, non-federal sources, and you have the ability to confer benefits or withhold benefits, or somehow to materially affect, the lives of and livelihoods of folks outside of government, that what may otherwise appear to you to be a benign sort of, maybe even almost sort of a customary sort of thing, that people want feedback about how they're doing, and if they're doing well, they'd like to be able to know that people are in a position to be able to comment on the good services that they're providing. But we've got some different elements here that I don't think, this isn't sort of typical of send a letter to the person's supervisor saying what a good job they did. Here where the person is first of all asking for the endorsement. And doing so in a public space. Do so in a public space, and doing so through a vehicle that, would also require something of the individual as well. I don't think everybody's on LinkedIn or is necessarily a participant in LinkedIn. And so the vehicle through which it would be done and the nature of the relationship between the government employee and the people that this employee would be asking this favor of, I think suggests that this would probably not be an appropriate thing to do.
In situations like this, I always like to ask myself, how would I feel as the recipient of this request?
Exactly.
Because the intention of the employee here is probably quite anodyne. There isn't an intent to cause offense or compulsion. But the recipient of that request may very well feel that, and I think that this is the kind of relationship where, regardless of how gently the request was made, it might be understood to be sort of compulsory.
Exactly. So let's go to the next one. There's sort of a variation on this theme. So a Department of Commerce employee meets an executive of a car manufacturing company at a conference. Government employees meet people at conferences all the time. So now he would like to call this executive to ask for information and advice about the availability and advisability of one of the company's new products, which he is considering purchasing.
Okay.
What do you think about this?
I don't know. This one doesn't strike me quite as clearly as the last example. There's some factors in here that maybe muddy the analysis, but we have this concern that they have special access to information and people by virtue of his official position, the commerce employee's position, and it seems that this information, these relationships are being put to work for a private interest, namely the employees.
And I think a couple of points here that occur to me as well is again, it's coming from the perspective of what is that executive of that car manufacturing company going to think or feel if he has casually met a federal employee who works for a department that may or may not be in a position to affect him in the conduct of his business, but having perhaps briefly met this individual now is presuming a level of familiarity, number one, under the guise of this official authority that he has, because it's through that mechanism that he met this executive. And so under the color of that authority is now presuming sort of a level of familiarity and is now asking for information that this executive may or may not typically give out to anybody.
And I think there's a muddying here. It would not be clear to me as the executive receiving this request for information from whom the request is coming, Is this being brought by this employee on behalf of the federal government, or is it being brought by the employee on his or her own behalf? And my inclination to cooperate or to provide the information might be very different in those two cases. And to the extent the employee might be deliberately or even unknowingly posing that dilemma, we might have a problem.
And if it seems to me that one of the difficulties we run into here, or the potential problem we run into here, is there some sort of presumption of tit for tat then? I mean, is the executive then going to be under the impression, well, I offered information and was free with information to this employee about something that I don't want to say was proprietary, maybe not necessarily, but that, I did this individual a favor by giving them information that they requested. Can I expect the same from them in a circumstance where I want information that maybe isn't necessarily something that the Department of Commerce would necessarily give out routinely? So you create this, you create a reciprocal kind of
a confusion, really. It's confusion about, about whose interests and perspectives do we need to be considerate of.
So the bottom line here for me, and that I'd like you all to sort of just really think about is, any sort of circumstance where an employee is asking a favor of or is seeking some sort of benefit for themselves personally, and they're asking that favor or seeking that benefit under the color of their official authority, even if ultimately the benefit or the favor they're seeking would be for them to use for themselves personally. I don't think it has to be explicitly coercive or some real explicit sense of inducing a favor. I think the mere requesting a favor or seeking a benefit under color of authority is
potentially a misuse of public office for private gain.
Exactly. Okay, so let's move on to the next. So if we look at, so that's 702A. Now if we move on to 702B, 702B deals with a couple of different use of title, position, and agency specifically provisions. The title of this paragraph is appearance of governmental sanction. And so I think what we're looking at here under this paragraph are circumstances where when an employee is engaging in activities in a personal capacity, making sure that, as you said, that the waters don't get muddied. So we're looking at situations where somebody is engaged in an outside activity or has an outside business or is doing something in their personal capacity. They effectively have two statuses. They have an official government status and they have a private status. And it's a bad matter of not mixing up the two hats and keeping the two hats straight.
We don't want anyone to be confused about when the government is speaking and when the employee is personally speaking.
And I think it's something that we need to explain better to employees. And we're going to come up here to an example that's going to talk about government scientists. And I know personally from some conversations that I've had that scientists in particular, sometimes this is an area that I think just requires better explanation on our part. And that is this notion that you have a different status, that you have this official capacity status which is not the same thing as a professional status. It's official capacity means when you're doing something in your official capacity, you're speaking on behalf of the United States government. You're speaking as the United States government.
Right.
As distinguishable from a non-official or a personal capacity activity that may very well, in some respects, be related professionally to what you do for the government.
But it's not on behalf of the government.
But it's not on behalf of the government, and you're not allowed to presume to speak on behalf of the government absent approval to speak on behalf of the government.
Right.
So that's really what this section is trying to get at. So if we look at the first, I want to take this like two different things that get discussed in this paragraph, and I want to take each separately. The first is dealing with use of title or any authority associated with his public office in a manner that could reasonably be construed to imply that his agency or the government sanctions or endorses his personal activities or those of another. And then it explicitly references the teaching, speaking, and writing in a personal capacity provisions, which are separate provisions which talk about when you may or may make reference to your title or position.
Yes.
Okay, so we're going to stop there because there's a whole nother set of stuff that gets dealt with in the second half, and we're going to get to that, and I know that's of interest to a lot of people, the letters of recommendation piece. But we want to stop right now and just talk a little bit about use of title, position, and agency in 702B and 807B1 and B2. Now, OGE has issued a couple of legal advisories that we've made reference to, and I want to talk a little bit about those before we get to our questions. In OGE 10X1, what OGE has attempted to do there is to clarify the provisions in 807B1 and B2 that talk explicitly about when you may make reference to your title when you're teaching, speaking, and writing. And 10X1 acknowledges, Patrick, that there are those two sort of distinct pieces in 807 that say, in the one instance, that if you're going to be teaching, speaking, or writing, you can make reference to your position as long as it's only one of several biographical details, okay? So there's that, and then the second one deals with if you're being published in a professional journal, that as long as you have a disclaimer, a prominent disclaimer saying that the views represented do not necessarily reflect those of the United States government. And in 10X1, what we're basically saying is, yeah, those are fairly bright line rules, but for example, with respect to the first one, where you're giving it as one of several biographical details, 10X1 is saying, okay, OGE hasn't created any bright line numbers for
how many details you have to include.
Exactly. So and we're not planning to do that, and we have no intention of doing that. And we recognize that there may be circumstances where editorial decisions are made outside of the employee's control.
Exactly.
And so we don't want to be punishing employees who are making an honest effort to comply with that.
Right.
So in that circumstance, we've said you need to look at the totality of the circumstances, and we need to make sure that we're taking in context, we're taking in a whole lot of other considerations.
And again, this is a balancing act. We're not trying to prevent employees from being able to share their sort of professional qualifications. We're not trying to require people to ignore their service to the government when they're demonstrating their qualifications, but we are trying to make sure that whatever activity they're engaging in doesn't appear to be coming from the United States government.
Exactly. And so what 10X1 is trying to say is that's the reason why we need to be looking at context. Context is everything. So we want to look at what the actual language is. We want to look at the circumstances under which the title is being used and the manner in which the title is being used before necessarily arriving at the conclusion that a particular manner in which a title was used is necessarily a misuse of position or a misuse of title, because it doesn't explicitly fall within the parameters of 807 B1 or B2. So I would advise you to take a look at 10X1. And then subsequent to that, we issued OGE LA 1408. Now, whereas 10X1 is really dealing with the teaching, speaking, writing provisions, 1408 is trying to take on the bigger picture of there are a lot of other circumstances where you might regret, like, for example, Patrick, when might you, outside of teaching, speaking, writing, make reference to your title?
Well, let's see, in other kinds of outside employment, if you have outside employment that's maybe not necessarily directly related to your duties, but where your duties are maybe a part of your qualification to hold that outside role, that's a place where you might find reference made to your employment with the U.S. government.
Yeah, and I think that what 1408 addresses itself to are exactly those kinds of things, where you're involved with like a professional organization, right. And how are you identified on their website, instances like that. And what 1408 tries to do is to basically lay out some factors that you should consider that would either increase the likelihood that a reference could reasonably be construed as implying a government sanction or endorsement. And if you go to the next slide, Patrick, this is kind of the laundry list of what we've given, and these all make pretty good sense, don't they?
Yeah, I think these make a lot of sense, and I think what we're trying to prevent here is this confusion about whether, say, you're serving on in a professional organization. If it looks like you're serving officially when you're in fact not, those are the kinds of places that we are concerned, right? Hence the nexus in the first standard, and then the relatedness standards.
Yeah, so we want to be looking at the way the nature of the organization and how closely are its activities tied to like what the employee actually does for the government, so that there could be a confusion.
Right.
I think we have particular sensitivities about if ever an employee's title or authority is used to actually promote or market. Right. The activities or the positions or the products or services of an organization. So there we might want to take a little bit more care.
Absolutely. For the mere use of your title or position in furtherance of a private commercial interest satisfies so strongly the private gain portion of our analysis that I think we have to be extremely careful.
And again, and I think any indication that this employee's official position was in any way being associated with and therefore could be confused with supporting that type of an activity, again, I think we're much more sensitive when it comes to those types of activities as opposed to people's customary. I mean, it's customary for people to be identified by the work that they do, right. And I think that we're trying to recognize that as a customary practice, that federal employees should not have to disavow their jobs as federal employees in order to participate in outside organizations.
Right. Again, we're asking about how the title or the position is being used, right, and to what end.
Right.
So if we had an employee who was engaged in some sort of outside consulting activity, and they said, this employee has provided services to company X, company Y, company Z, agency A, agency C, and they're highly qualified to provide the services that we provide. We're talking about the qualification of the individual.
Right.
If we identify them only by their current government title, it appears that we're indeed using the public office for private gain.
Exactly. So let's move on to we have a couple of examples here, I think, to help sort of get us into and illustrate kind of what we're talking about here. So the first one is, and this is a sticky one, whether government scientists could use their titles and their agency names in slideshows or other presentations at professional events where they attend in a personal capacity.
And I think this is a good question, and I've seen this asked a lot, and I think one of the concerns, some reasons that employees want to do this is for contact purposes. If you'd like to get in touch with me, if you'd like to work together, or if you'd like to provide information, they'd like to be contacted in their official capacity. But there are risks here. Right. Because there is a danger that the recipients of this activity, or the recipients of the communications they're making, could perceive that as implying that those communications were being made on behalf of the U.S. government. Right.
And I think it's particularly tricky when professional organizations may very well be very interested in the research that the individual is doing on behalf of the United States government. I mean, I think it's in those circumstances where agencies, I think, are on the spot to sort of like decide when it is appropriate for their employees to actually be engaging in those activities in an official duty capacity, right, instead of making them sort of choose between information they can provide and the status that they have to be in.
Yeah, and I think that's a good piece of advice for ethics officials is to consider whether or not this activity would be better undertaken as part of the official duties. That can be limiting in its own way, because we can only present information on behalf of the U.S. government that we're permitted to present on behalf of the U.S. government. Right. But that may take away some of the confusion. So thinking of sending someone only in their personal capacity as a remedy to those kinds of limitations is not always the best solution. Sometimes it is better if it would be more appropriate for them to attend officially, to simply send them officially, because then these problems go away.
Yeah. So, and I think, again, being mindful of the 807 provisions as well, and the restrictions on compensation for teaching, speaking, and writing that relates to your duties. Those are other things that we have to consider in terms of if people are in effect taking their government work and presenting it in a personal capacity.
Right.
Even if it's in the guise of a professional association, when there's compensation involved, then we have a whole nother set of concerns that we have to be mindful of.
Absolutely. So we can come to sort of a rock and a hard place situation, but we want to think through those permutations and the the possible outcomes or limitations of each.
Right. Okay. So next slide. Okay, so now we have a slightly different fact pattern here. Now we have a law enforcement officer who wants to make reference to his or her current position in advertising or promoting their security consulting business.
And this one causes me some immediate concern because the private gain portion of this is so explicit, right? We know what we're trying to do. We're trying to make private citizens money in a commercial activity, right? We're looking for clients. So we know that there's a private gain involved. So the concern is, are we using the public office to further that private gain? And I think this is a very dangerous area.
Well, I think it's perfectly fine for anyone, including a law enforcement officer, to establish their bona fides if they have a business. And if their outside business is permitted and is related to the work that they perform for the government, I personally don't think that there's any problem with making a mention, for example, to say, I have 12 years of federal law enforcement experience.
Right.
I don't think that's the same as saying, I am currently an FBI agent in the something, something, something division, where you're making explicit reference to your current position, which could on some level lead someone to.
Well, you could see a case where maybe on a business card for the outside business, right? You have the owner and CEO of XYZ security consulting business, and then you have the photograph of the person, and underneath it you have their official title.
Right.
That would be confusing to me as a recipient of that. It's obviously being used for a private commercial purpose, and that would cause me some serious concern. However, 12 years of law enforcement experience doesn't suggest to me, the recipient of that communication, that the government is indeed going to provide these services to me or in other ways endorses those. So I think this is why it's really important, the thing we discussed right at the beginning, that the principle is primary and that we provide guidance, but the sort of totality and the judgment required to do this is really one of fact matter determinations.
And again, it's you can make reference to your position. It's the manner in which you're making reference to your position, and whether or not it's appropriate to make any kind of explicit reference to your position, or if you're actually just more or less referencing your experience in a broader, more general way, like federal law enforcement, federal auditing, that sort of type thing, where you're talking more about the professional service, like what it is, rather than specifically for whom you're providing that service.
Right.
Okay, next slide, please. Generally speaking, this is a question we get a lot about, and we're not going to spend a whole lot of time on it, although I know people have oodles of questions about social media and use of social media. We issued a legal advisory 1503, and that's also in that list of advisories that you have the link to, where we talk about basically what OG currently feels comfortable talking about and what is under our cognizance. So as a general proposition, may government employees identify their federal positions in their social media accounts? And the answer to that is yes, right?
Yes.
Okay. Don't mean to shortchange that one, but we have a whole legal advisory on it, and we've got a lot more territory to cover here. So, the second half of 702B, the first half talked about the title, position, and authority. The second half of 702B, I know, causes people a lot of confusion. And this is the reference to that an employee may sign the letter of recommendation using his official title only in response to a request for an employment recommendation or character reference based upon personal knowledge of the ability or character of an individual with whom he has dealt in the course of federal employment or whom he is recommending for federal employment. So when we parse that, the takeaway I want you to start out initially, because it's going to help explain my methodology here, or what we're going to do over the next several slides, is that there's really sort of two pieces here. One is dealing explicitly with employment letters of recommendation.
Right.
Okay. And the other is talking more about these general sort of character references or other forms of reference that may not be explicitly for employment. They may be for other
purposes.
things.
Yep.
Okay, so we're going to start, everybody, with just looking at letters of recommendation for employment, okay? And this chart that I've given you here is to sort of try to help parse out that language in the provision. So an employee may use their title and they may use agency letterhead in two instances. The first is if they're recommending anyone for federal employment.
Right.
Okay? So as long as the employment is federal employment, you may use your title and letterhead to recommend anyone, irrespective of how you know them, irrespective of whether you've ever worked with them in federal service. If it's for federal employment, you may use title and letterhead.
And this kind of makes sense to me, actually, because the idea here is that you're helping to provide the government with information about candidates that it would like to hire.
Right.
And the government benefits when the picture of candidates for government employment is more complete.
Right.
So your contribution to the completeness of that application for employment accrues a benefit to the government. So we say, because that's the case, we permit you to use title and letterhead to execute that activity.
And I think the understanding too is that, who better to tell the government who to hire other than other federal government employees who actually know what the qualifications are that the federal government should be looking for, right, when hiring folks. So that's the first part. The second is now when you're recommending for non-federal employment, okay? So if you want to recommend someone for non-federal employment, you may use your title and you may use letterhead if you can write that letter of recommendation based upon your knowledge of the person which you acquired through your federal service. So here there has to be a nexus between your understanding of this individual and your federal service. So it has to be somebody that you know through your government job and can make comments about their qualifications based on your knowledge through your government job.
And I think this one also makes sense to me, especially when you think of the kinds of people that you would probably ask for a letter of recommendation as a federal employee looking for outside employment, or employment outside the federal government. That it's sort of part of your responsibilities as a supervisor or colleague to provide feedback and commentary about the performance of colleagues or subordinates.
Right.
So we view this as kind of a part of your responsibilities as a supervisor or a colleague. To your government role. It's a customary part of being a coworker.
Yeah, and it's not a misrepresentation, because the basis upon which you're making this recommendation is based upon the experience you actually had of this individual in the federal workplace, right, in your federal capacity.
Right.
So it's not misrepresenting your opinions as merely personal ones. They are ones that are acquired through your official conduct of your official duty. So, for example, we had summer interns here this summer, right, and I had the privilege of working with a few of them. And so if they were to call or ask if I could write a letter of recommendation for them for some future employment because I worked with them during the summer, that would be the basis upon which I could do it, and I would be able to use my title and official letterhead to do it.
Right.
So the only time you may not use your title and letterhead in the context of letters of recommendation is if it's for non-federal employment and your knowledge of this individual is personal and it's not at all based on your experience through federal service. Okay, so let's go to the example I have, the question that I do, and to sort of flesh this out. So the question to test your understanding of what we just talked about is, so could a government employee write a letter of recommendation using her title and agency letterhead for her neighbor's daughter who has applied for a position with the Department of Treasury?
Okay, so let's see. I'll sort of parse through this using the chart we were just looking at. So this is not someone the employee knows by virtue of federal employment.
That's right.
However, it is for a position with the federal government.
That's correct.
So this employee would be contributing to the fullness of the government's knowledge about this candidate in writing this letter.
That's right.
So I think this would be an acceptable use of title and letterhead. That's
correct, because it is a letter of recommendation for federal employment. And once you've established that, you can use your title and letterhead. Right. Okay. So then the following question is, so what if the neighbor's daughter was applying to a bank?
So it's a private organization outside of the government. Right. So I don't know the neighbor's daughter by virtue of my government position.
Right.
And she is applying to a position that's outside of the federal government. So no benefit's going to accrue to the government by virtue of my using my title and letterhead in this way. So this would seem to be prohibited. It's not an authorized use. It's not an official use of my title or agency letterhead, and it doesn't fall within the interest of the government to do this.
That's
So
right.
it would seem to be both a misuse in that case and also for private gain, because presumably the daughter will benefit or accrue a gain by virtue of receiving this recommendation.
Okay. And let's be perfectly clear here. What we are talking about isn't whether or not you can write the letter of recommendation. It's whether or not you can use your title, like sign with your title, and use agency letterhead. So in the first instance, you can sign the letter using your title and using agency letterhead. In the second instance, where it's going to the bank, you could still write that letter of recommendation.
You just could not.
You just could not sign it using your title and position, and you could not use agency letterhead. Now, what about making reference to your position somewhere in the body of the letter?
Yeah, see, I think this is another place where the principle is very important, right? We have to look at the nature of that reference to determine whether or not it would constitute the appearance of government sanction or otherwise appear coercive, so that the recipient might view this as an official communication or merely a reference that's establishing my qualification to make these judgments about the person.
Exactly, and we have said that when it's appropriate and when it is material to like establishing your bona fides. I mean, because let's face it, when somebody's reading a letter of recommendation, they want to know, why should I listen to you? Like,
right,
what do you possibly have to contribute to
right.
your knowledge of this person's character and abilities? So making a reference to your position in the body of the letter is not necessarily a problem. You can do that. But I do agree with you, Patrick, in that there may be some circumstances where you want to advise employees to be really careful and to make sure that they're not inadvertently suggesting by the way that they
right.
Disclose their position or authority, that they are in any way suggesting that they are.
This is the view of the federal government.
That this is the view of the federal government, or they're trying to bring the authority of the federal government
right.
to bear in the letter of recommendation.
Yeah, because I think the relationship between the potential outside employer and the government agency might be something to consider, because we wouldn't want the recipient of the letter to feel coerced in any way. So if you were, say, a regulator of this bank,
right.
Maybe their examiner, I'd have serious concerns that they could receive that without feeling some coercion based on your official title. Yeah.
Okay, so that is actually a nice segue to our next slide. The next slide, I'm referencing yet another OGE informal advisory opinion, and it's 07X11. We've given you the hyperlinks to this one as well. And this one is really useful because, as we all know, letters of recommendation are not the only contexts in which we are sometimes asked by coworkers, friends, and others to provide employment recommendations or other types of employment contacts. And so what 07 is saying is, okay, in these other circumstances, so for example, making a phone call to recommend, or making some other sort of employment contact on behalf of a friend or a coworker, when is it appropriate? How is it appropriate to do, if it is appropriate to do? And OGE gives you a list of factors to consider, including, okay, so who initiated the employment contact? Did the prospective employer contact you, in which case it seems appropriate or more appropriate to just respond to that contact,
right.
Where it might be a little less appropriate for you to cold call someone who's not expecting your phone call,
right, to initiate the contact
about the employment arrangement. Does the employee have an independent relationship with the prospective employer? Is it a prohibited source? So again, looking at the relationship between the entity that's
receiving the
communication, and the government agency and the employee and their relationship with the organization. Is it a position that's actually even been applied for, or is this one of those where you're doing a fishing expedition to find out if they would be interested in?
Right.
Government resources, whether any government resources are being used, government phones, government emails, those are all government resources, and could give the impression that it's a government sanctioned thing or an official communication, so you want to be mindful with that. And then obviously looking at the totality of what the employee is conveying to make sure that there isn't any suggestion of
sort of coercion,
tit for tat, reciprocity, that sort of thing. So I recommend 0711 to you for other than letters of recommendation for employment. Next slide, please. The next area that it's similar are other types of character references, other types of support letters that aren't for employment per se, but that have the nature of a character reference, which we have also said there are circumstances when you may use your title and your agency letterhead for character reference types of things. The area where it comes up for us most often are immigration support letters, and so much so that we actually issued an informal advisory on it, OG 07X7. Now, this same issue comes up in the context of letters of recommendation, and what I'm about to say applies to letters of recommendation for employment too. But we talk about it more explicitly in these immigration support letters because there's a lot of question about whether or not engaging in that kind of a communication would implicate the criminal statute 18 U.S.C. section 205. And what does 205 generally prescribe, Patrick? What does it prevent employees from doing?
So generally, employees may not act as agent or attorney or otherwise represent third parties before an agency of the United States government.
Okay. So in this instance, we'd be concerned about 205 because an immigration support letter is clearly going to go to some sort of federal entity that adjudicates immigration issues. And so then the question becomes, is the nature of these letters such that you would be deemed to be acting as an agent, attorney, or otherwise representing the immigrant on whose behalf you were writing this letter?
Right.
And OGE's opinion in 07 is based upon an Office of Legal Counsel opinion, which basically said that typically whenever you're engaging in writing something of the ilk of a character reference, where you are opining on the qualities and character of an individual, that is fundamentally a self-representational act.
Right, because the person who's requested or on whose behalf you're writing this letter doesn't exercise control over you, right? You're not literally under their control.
Well, it's saying as long as the character reference is based on your own knowledge of the character and abilities of the individual, so it is a representation of your own opinions of this individual, then that's self-representational in nature, and that's not a violation of 205.
Right.
So the admonishment here is that when you're trying to determine whether or not someone is acting as an agent under 205 in writing and submitting one of these letters, you want to make sure that the federal employee is not in any way under the control of that person on whose behalf the letter is being submitted.
That they're merely making a statement as to their own experience, their own knowledge on their own behalf.
Right. So an example, I think, of where you might have a question about whether or not the employee was actually under the control of the person on whose behalf they're writing the letter would be, let's say that the person seeking the immigration support letter actually just provided a template to the employee and said, fill in your name and your address, but they've basically written the entire thing and provided the entire content of what is to go into this letter, and this employee was just asked to put in their personal information. That suggests to me that you're under some degree of control and direction by the immigrant.
Right.
Because it's not stating your personal opinions. You're just merely assigning your name to opinions that were expressed by this individual.
Right.
So it would be a circumstance like that that would transform what we have typically otherwise said is not a 205 concern into a potential 205 concern. Okay.
Okay, that makes sense.
So the next slide, please. So the question then becomes, well, okay, I can write the immigrant support letter, but could I use my title and my agency letterhead to write that immigration support letter?
That's a fantastic question. And I don't think we have such clear guidance in the regulation as we do in the case of the employment letters.
We don't, but we have said that what we'd say about letters of recommendation for employment apply here as well, which is if the basis upon which you are able to write this immigration support letter is because of what you've experienced of this person through your government employment. So it's through your service to the government that you got to know this person and that you can attest to their character and provide the letter, then you may use letterhead and you may sign using your title. Because again, it's a matter of, it's basically a quasi-official act that you're doing.
So if you had gotten to know this individual through, maybe they, through, professional work, maybe they were an official in a foreign country for an academic institution that you worked with closely in your official capacity, or otherwise that you had a relationship with them officially, then that would be okay.
Exactly, exactly. But it has to have been through your federal employment. So if the basis upon which you're writing this letter is because it's your next door neighbor, or it's a friend, or it's someone that you've met through some other nonprofit work or whatever, then under that circumstance, you could still write the support letter, but you could not sign it using your title and official position, and you could not use your agency letterhead.
Interesting.
Okay.
Excellent.
Next one. So similarly, there are other kinds of support letters. And again, we've got 98X18 talks about yet another instance where you could write this character reference type of letter, and it would fall within the same parameters of what we just discussed with immigration support letters, which is we had an instance where a former supervisor was being sentenced. They had been convicted of some crimes and were being sentenced, and some of their subordinates or former subordinates wanted to send letters of support for the sentencing hearing. And we said the same thing, that we think those letters are character references, so they involve self-representation, unless, again, obviously you would have some suggestion that there was some control or direction by the former supervisor.
Right.
So there's no 205 issue. And the federal employees may use their title and letterhead because obviously the way they know the supervisor.
They receive this information by virtue of their federal employment,
yes.
And they're speaking to things that they've experienced in the course of that employment.
Exactly, exactly. So hopefully that has cleared up some questions that folks may have had. If you haven't read those opinions, I recommend that you do so.
Yeah, it's interesting. We've written quite a lot on this over the years.
Yes, we have.
For such a seemingly simple regulation, there's a lot of sort of nuance and complexity.
Yes, there is. Okay, so the next provision is the endorsements provision. We're going to kind of touch and go on that because actually we're running out of time here and we've got a lot more to cover. But the endorsements provision in 702C, the takeaway I think in this provision, Patrick, is that agencies need to know that OG is not presuming in this section to tell departments and agencies what authorities they may have officially to endorse products, services, or enterprises.
Right.
So this provision is reaching to
the individual conduct of employees.
Yes.
That's why we call it the standards of conduct for employees of the executive branch. We're regulating conduct by employees.
Right. So we are concerned about when employees are without the authority of the agency engaging in activities that would make it appear as though the government endorses a service, product, or enterprise. Let's talk about these two questions, and then I have one final point I want to make about circumstances where the agency itself has the authority and sort of some advice about when you're exercising that authority. So the first question we have is, an employee sends an email to everyone in her agency to inform them of the special discount program her cell phone provider offers to government employees. What do you think about that, Patrick?
I don't know. This causes me a little bit of concern. Because this employee presumably is sending this email, an official email account.
Right.
And they're doing so maybe not with the intent of drumming up business for this private company that offers the discount. But that's likely to be the effect of the communication. So I'd have some concern that this would be a misuse of government property or time.
Yeah, and I think that it could be mistaken as some sort of that you're trying to endorse this particular cell phone provider over others.
Right.
And I think particularly if an agency has the ability to do that and elects to do that, that's one thing. But if individual employees are circulating suggestions to their other government employees in government email that these are the cell phone providers they should be looking for and looking at, I think this is the kind of thing we'd want to.
And I think this gets
against.
Confusing because I know I frequently receive emails from certain government officials in our agency informing me about the availability of certain official benefits. Right. Changes to your health insurance benefits or the availability of certain insurance programs or what have you. And I could, as the recipient of this communication, become confused and view this as a government endorsement of this program as part of my sort of official benefits.
Question 2 is an interesting one, and this is one we've gotten on more than one occasion. A company that provides personal retirement investment advice would like to come and speak to your agency's employees about retirement planning.
I think this is a more interesting one, because this is a question of the agency's disposition of its own resources. In this case, the resources would be probably some conference space and maybe some official time. And the misuse regs don't speak specifically to this. But, I do have some sort of broader concerns about, general fairness.
Right.
Is this an opportunity available to all investment advisors?
Exactly.
Or are we providing a special preference to this one provider?
So I think that and that's exactly the point I think that I'd like to sort of leave folks with is, if the agency makes determinations about granting access to its employees to certain institutions like retirement investment advisors and things like that, it's not for OGE to question whether or not an agency has an authority to do that under whatever, authority you claim to have that. But what we do say, and what we do sort of suggest to ethics officials that you do, is to, suggest to your managers or the folks who are making these decisions exactly the question that Patrick posed, which is there a fundamental fairness issue here? Why are we granting access to our employees to this one investment firm and not to any other similarly situated investment firm that's out there? And at least be prepared to answer that question,
And this is about prudential management reasoning, right? This isn't about contravening the ethics rules. It's about thinking carefully about how your organization makes decisions for itself. And fairness as a principle of the sort of government's work isn't unique to the standards of conduct.
Right. Now, when you do have individual employees who are making those decisions on behalf of the agency, e.g. the agency said, yes, we're going to go ahead and we're going to allow this thing to occur, you still have to look at the individual employees who are making those decisions or who are involved in that, and also make sure that they don't have additional conflicts or impartiality issues or other sorts of things that might give cause for concern of misuse of public office for private gain.
Right.
So the endorsement thing isn't the be all or end all to these kinds of questions. There are other things to consider.
Right. In the case of question 2, we could imagine the employee who has suggested this activity maybe has an outside relationship with this provider of investment advice, and they are kind of coming maybe not on their behalf, but for their explicit benefit,
right,
to try and secure for them agency resources. And I think in that case, it would clearly contravene the principle of misuse of public office for private gain. Right, they're inventing an official activity for this person's benefit. Right,
exactly. So you want to be looking at individuals' relationships with organizations, both in an official duty way, but also in the sort of like the personal way in which they have affiliations or engagements with these outside organizations. Okay, next one. The 702D, I think, is a provision that most people are not entirely familiar with, or maybe don't come across as frequently. So I'd like us just to really, really quickly take a look at 702D, because it's the title of it is Performance of Official Duties Affecting a Private Interest. And it says, to ensure that the performance of his official duties does not give rise to an appearance of use of public office for private gain or of giving preferential treatment, an employee whose duties would affect the financial interests of a friend, relative, or person with whom he is affiliated in a non-governmental capacity shall comply with any applicable requirements of 2635.502.
So the secret covered relationship.
Yes, it's the secret sort of expansion of 502,
right,
outside of 502. It cross-references you back to 502, but I think in a nutshell, what we're trying to get at here is whether or not there are circumstances where an employee can engage in official duty activities that could affect and benefit people with whom they have affiliations in a non-governmental capacity.
Right.
So it's an impartiality type of concept.
Right. And it also deals with financial interests here as well.
Right.
And I think this is kind of an interesting point to keep in mind, and that's the relationship of this provision to 18 U.S.C. Section 208. Sometimes we don't have an explicitly imputed financial interest under Section 208. We tend to look just at Subpart E of the standards, but Subpart G is another place to look.
Right.
Because notwithstanding anything in Subpart E, we cannot use our public office for private gain. So if we're going to engage in official activity that will accrue a benefit to someone with whom we have an outside relationship, that could very well pose a contravention of Subpart G.
Exactly. And I noticed that what I've put on the slide here, I'm taking us back to that original scenario we talked about, that MSPB case where the SES official was removed for basically using her position to get her son's fiance a job in the activity where she was working. And if you remember back at the very beginning, I said, when it comes to charging folks with a violation of the standards of conduct. In this particular case, the charge that was brought before the MSPB was one of misusing government office for private gain. The agency did not attempt to shoehorn this into 702D, and 702D might not have been an entirely perfect fit. But that's, again, just to remind you that you don't necessarily have to go into the particularities of an A, a B, a C, or a D.
You just have to demonstrate that someone has misused, which is improperly used,
right,
their public office for the private gain of themselves or someone else.
Themselves or someone else, exactly. Okay. So if we go on to the next slide. Patrick, I'm going to let you talk a little bit about non-public information before we get into these questions, because I know this is an area in particular that you find this provision a little bit intriguing. Is that an appropriate way to describe it?
I think there's simply a problem with the way we shorthand this provision.
Okay.
And it's important to think about what we're actually discussing here. We're talking about the misuse of public office for private gain.
Mm-hmm.
And then when we get to non-public information, we're talking about the misuse of non-public information
mm-hmm.
for private gain. So this isn't a per se disclosure bar, but a prohibition on misusing non-public information for private gain.
Mm-hmm.
It's the nature of the use of the non-public information that we're getting here,
mm-hmm.
and the purpose for the use.
Mm-hmm.
And I think when we tend to sort of shorthand this for employees, what we tend to say is you can't disclose non-public information. And that's not actually what we're saying here.
Mm-hmm.
So if we look at the prohibition, we say an employee shall not engage in a financial transaction using non-public information. And we take that directly from the 14 principles.
Mm-hmm.
Right? That's literally in there. So you cannot engage in a financial transaction if that transaction is based on non-public information.
Mm-hmm.
So this is kind of the insider trading thing.
Right.
And the interesting thing here is there needn't be any disclosure here. Mm-hmm. Right, we can contravene this this provision without disclosing any information. Mm-hmm. Simply by having the information and making a decision based on that information, we can violate. And I think that's often lost.
Right.
Yeah. It also says we can't allow the improper use of non-public information to further our own interests or those of another, whether through advice or recommendation or by knowing unauthorized disclosure. Mm-hmm. So we're explicit. There are lots of ways that you can misuse non-public information other than disclosure.
Right.
We can advise someone to engage in a financial transaction based on non-public information. Mm-hmm. We can make a recommendation, or we could indeed make an unauthorized disclosure. But mm-hmm. it's not a per se prohibition. It's exclusively about disclosure.
Right. Right. Okay. So let's look at these two questions as kind of an illustration of what we're talking about here. First question: employee's been given access to information about an impending indictment that has not yet been announced to the public. The employee short sells stock in the company that is involved in it and will be affected by the indictment.
Yeah, so there's not been a disclosure.
Right.
Doesn't matter.
Yeah.
This is non-public information. We're using it to profit financially. Mm-hmm. Right. We're shorting the company. That's a misuse of non-public information for private gain.
Okay. And Q2, an employee with access to audit, investigative, and enforcement information in his agency's computer system uses that information in his private consulting business.
Well, we certainly have the private interest,
yes.
Private consulting business. It's a commercial enterprise, and this isn't an authorized use of this information.
Right.
So, yeah.
Yeah, and so we don't even need to know to what extent that this individual was disclosing this information to clients. It's the fact that this wasn't an authorized use
right.
of this information.
They could be using this for business development. They might not even tell the potential clients, where this information came from or how they knew they needed these services. Mm-hmm. But you can't use non-public information for private gain.
Right, right. And the other thing I'd like to point out to folks too is make sure that you do pay attention to what constitutes non-public information, because it's stuff that's obviously statutorily protected, and all those proprietary information. Yes, all those things are covered. But it's also anything that has not actually been disseminated to the general public and is not authorized to be made available to the public on request. So it's a little bit of broader definition than I think we would normally
So this could definitely be information that is intended to eventually be made available to the public.
Mm-hmm. But it has not yet been authorized.
So maybe you're going to front run a press release.
Mm-hmm.
Your agency is about to announce an indictment or something,
mm-hmm.
and you decide that you're going to go engage in a financial transaction based on this announcement before it's made.
Right.
Right. The fact that it's eventually going to be made public doesn't absolve you of the misuse of non-public information, because at the time you used it, it was non-public.
Exactly. exactly. Very good. Okay, next section. Okay, the next section is the use of government property, and I think this is one that we sort of all think we understand what that means. And it's an area where the agency has an enormous amount of discretion. I mean, this really does come down to agency heads being allowed to create housekeeping provisions and create de minimis personal use exceptions. Because, I mean, let's face it, Patrick, we need to be good stewards of government resources and government property, but we are also, cheek to jowl with each other 8.5 hours a day, 5 days a week.
Right.
So there is an employee morale issue that comes into play with.
Also, employees' lives don't stop the minute they walk through the door.
Mm-hmm.
Things happen, life goes on, kids get sick, spouses have car trouble,
Mm-hmm.
Things happen.
So I think this is one area where agencies, might want to be particularly careful about informing employees about where the confines are of what in the agency's mind is a reasonable de minimis use and what would constitute. And that's hard. I mean, it's hard to draw those kind of bright lines absent a set of facts. I understand that, but I think it's an area that we need to be mindful of, making sure that we think employees are adequately on notice about what constitutes misuse. And this, again, is another one where it's in the principles. It's at B9, in addition to being a separate provision in the standards of conduct. And I have seen in some of these MSPB cases where charges are brought under both the principles and the articulated standard in Subpart G.
Yeah, actually, Diana, I think, discussed that this spring when we were talking about the elements of ethics enforcement. So that is very interesting. And I think this is an area where in misuse policies, to the extent you do have some bright lines in those policies, sharing those and sharing them frequently is very helpful, because while they might not be exhaustive, they certainly indicate the thinking of the agency. So if there are certain activities that are definitely prohibited, do share those and provide the context of the rest of the policy.
Because this is one area too where I can assure you employees are observing each other's use of government property. So if there are ways in which you can try to create some bright lines, I think so much the better, because this is an area where I think, I don't want to say monkey see, monkey do, but I think that, your de minimis use policy becomes a matter of how it's practiced among colleagues rather than what your document says.
Yeah, there's a lot of possibility for erosion over time.
Right.
So if you have bright lines and you can remind employees of those bright lines periodically, you can prevent sort of that erosion.
So our first question that we have, and it's surprising because we have actually gotten questions at OGE about this, and I'm assuming that many ethics officials possibly get these questions as well, which is, not only may employees use government resources for planning, announcing, and holding social events like baby showers or retirement parties, but kind of like, how much may employees use government resources to plan, announce, and hold social events like baby showers or retirement parties?
Right, and I think this gets to not just an ethics issue, but also a management issue.
Exactly.
Right, what we're talking about is ensuring the efficiency of the service and not denigrating the workplace's ability to meet the official goals of the organization.
Right.
So if I was the ethics official sitting in the agency, when you have to stop doing this is when it starts to adversely affect the workplace.
Exactly. So, because I think, again, this is one of those things where, maintaining, the efficiency of service is something that also has to be balanced with employee morale. And I don't think that anybody wants to create draconian rules that make employees feel like working for the federal government is punitive, and that they're never allowed to have any sort of social interaction. There's never, allowed to be any kind of personal, private esprit de corps. It's always a matter of moderation. It's a matter of, manageable levels of use. So, but I think this is an area where the more that agencies can articulate these things, that, for the most part, we encourage or we allow, we permit blah. However, we discourage X.
Right.
And that leads into question 2, which is how much personal use constitutes misuse. And again, this is tough. It's tough to know where to specifically draw the line.
Right. And, I think it can be helpful here to go back to the principle, right? Generally, we're talking about use of public office for private gain. So the nature of that private gain is important. So, I think, the furtherance of outside commercial activities, we can certainly, prohibit. But then when it comes to an employee's personal use for family reasons or social reasons, it gets a little trickier, and we have to look at whether or not the efficiency of the service or the employee's ability to conduct their official responsibilities is being eroded by this activity.
Right. If you can give me the next slide, Patrick. This is another MSPB cases in this list of cases that we've given you. This is Smith versus Department of Energy. And here we had an HR assistant. She received a 30-day suspension for misusing government property and for violating the personal use policy. So this is another reason to sort of maybe to take a look again at your personal use policies and see to what extent they serve as a good notice to employees of what constitutes misuse of government property and government time. And she was cited for sending over 4,000 personal emails and emails containing inappropriate comments and excessively using the internet. So clearly 4,000 personal emails, I think by anybody's estimation, would constitute a misuse of your government time. And
I'm not sure I've sent 4,000 personal emails in my entire life.
But again, interestingly enough, in the MSPB case, they do make reference to the actual principles here, and the one principle that was, I think, cited in this case was, I don't think it was just the use of government property. I think it was the use of government time in an honest effort to perform your duties.
Right.
And they do cite that language in particular, saying that this was an indication where she was not engaging in an honest effort to perform her official duties in violation of that principle.
Yeah. Another reason to look at the principles.
Yes.
In addition to the specific provisions of the rule, because they can help us.
Yes, exactly. So you can have several of those general principles that are implicated in a particular situation, like a misuse situation like this one. And that segues us into our last area of Subpart G, which is use of government time. And again, this reflects back to 101v5, which is the honest use of your time for purposes of performing your government job. So let's just go into the questions, and then we can talk a little bit about what 705 gets at. The first question we have is, can a supervisor direct or request that an executive assistant or other subordinate perform personal tasks or run personal errands?
Well, let's see. I'll tackle this again from the principle of not using public office for private gain. Well, the private gain here seems to be the private gain of the supervisor, right? The government doesn't receive a benefit if the supervisor's dry cleaning is collected or letters are mailed, personal letters. And then, is this an appropriate use of a subordinate's time? Well, it doesn't seem to be an authorized use. If the government's not receiving any benefit, then the employee should not be engaged in that activity. So this would seem to contravene our principles here. But I also know in the private sector that helping executives, particularly high-level executives, live their lives is an understood part of the responsibilities of certain assistants. So this can result in some cultural friction,
right,
when we have certain high-level officials coming in from the private sector. But this applies no matter how senior the official is. The time of government employees should be used for doing government work.
And if we look at 705, I mean, it says explicitly, 705A talks about the use of an employee's own time. So it's talking about whether or not, authorized in accordance with law or regulations that an employee shall use their own official time in an honest effort to perform official duties. But there's a separate provision entirely that speaks directly to the use of a subordinate's time, and that's in 705B. And it says an employee shall not encourage, direct, coerce, or request a subordinate to use official time to perform activities other than those required in the performance of official duties or authorized in accordance with law or regulation.
So you're saying, Cheryl, even if my assistant really likes to pick up my dry cleaning during the workday, and I thank them a lot every time they do, that might also be prohibited because I might be offering some encouragement there.
Yes, and I think what we're trying to get at here is this isn't a matter of if you say it nicely and they agree that somehow that's not a misuse of the subordinate's time. It's that you really shouldn't even be suggesting to the subordinate that they can be doing things for you in your do things for the supervisor, that are personal in nature for the benefit of the supervisor. And in example one, we try to sort of head off this question of, well, what if the person volunteers to do it? You know, what if it's sort of consensual? What if it's, and we sort of tip our hat to that, but then we sort of turn it around and say, well, it may not be a problem under 705, but now it may be a problem under the gifts between employees rule. So if you look at example one after B, and if you look halfway down that paragraph, it says, where the arrangement is entirely voluntary and appropriate compensation is paid, the secretary may type the correspondence at home on her own time. Where the compensation is not adequate, however, the arrangement would involve a gift to the superior in violation of the standards in Subpart C of this part. So in effect, we're saying, even if you have an executive assistant or some other subordinate who is voluntarily agreeing to do this, if they elect to do that, they would still then be in violation of Subpart C, because they would be giving a gift to their official superior.
Right.
And there is no exception in the gifts between employees rules that would allow you to provide these personal benefits to your official superior.
No, and I think that makes sense, right? Because we want to prevent the abuse of that relationship. We want to ensure that supervisors are conserving government time for government purposes, and we want to avoid that misuse of the government authority for one's private gain or the private gain of another.
Right.
So that seems all consistent with the principles.
Yes. And the notion that sort of a superior-subordinate relationship is almost inherently coercive.
Right.
You know, we just don't want to get into the business of adjudicating when the subordinate was voluntarily and consensually giving their services to their superior.
And we also don't want to create an exception to the principle. That's
Right.
not what we're trying to do here. We're trying to articulate explicit circumstances in which the principle applies without diminishing the applicability of the principle.
Yeah, well, the point is the subordinate wouldn't be allowed to waste their own time.
Right. So,
you know, they wouldn't be allowed to do personal tasks for themselves on official duty time.
Right.
So why would it suddenly be permissible for them to do that for their superiors?
Right.
You know.
Exactly.
Okay.
Rules apply to everyone, no matter how senior.
Exactly.
Yes.
Okay, so our question two then, and this might make some ethics officials unhappy.
Sad.
Sad. They won't want to publicly announce this. Can a public financial disclosure filer ask a subordinate or an ethics official to prepare a draft of her public form?
I think this one's a little trickier because the completion of the public financial disclosure report is an obligation of public service for those who occupy those positions. So it's part of the official duty.
Yes.
It's an official activity. And the beneficiary of the filling out of that form is the government and the citizens.
Right.
I'm not really seeing a private gain here.
Right. Yeah, it's a form that the public financial disclosure filer is required to file as a condition of employment. They have to file the form. Just as with any other things that are a condition of employment, you know, doing that is sort of an official duty act. And so, you know, a superior can assign an official duty activity to anyone on their staff for whatever reasons they deem. And so there would not be a misuse of your subordinate's time if a senior employee were to ask a subordinate employee to prepare their financial disclosure form for them.
And I guess, you know, there's maybe a silver lining here, which is that agencies, you know, to the extent they think they need more resources to help with timely filing, want to direct some agency resources to the facilitating of timely filing, they may do so. So, you know, while it might be kind of not the most exciting day at work when your agency head comes by and drops off some financial information and asks you to complete the report, you know, to the extent that the agency desires to help people file timely so that you can provide better ethics advice. If you want to direct some administrative resources in that direction, that will be an appropriate use of government resources.
So that's it for our presentation. I know we've covered an awful lot in a very short period of time, but we think it's important for you to read the advisories that we have offered, which is why we gave that to you as a resource. But I would like to open up the phone lines now if folks have questions on the phone, and also if you're on the Google Hangout and you have questions. I know I've made you hold your water all this time, but for those who are still with us and have some questions, we'd be happy to take the remaining time to answer any questions.
Good.
Thank you. We'll now begin the question and answer session. If you would like to ask a question, please press star 1. You will be prompted to record your name. Please be sure to unmute your phone. Once again, if you would like to ask a question, please press star 1. You may withdraw your question at any time by pressing star 2. And we'll pause for just a moment to allow those questions to start coming through.
Okay.
Listen, and while we're waiting on questions, I'd just like to thank the folks who let us know that we were having a technical issue earlier. We're kind of all in this together, and our goal is to get you the information as efficiently and conveniently as possible, so it doesn't do anyone any benefit to ignore problems. So thanks for letting us know so that we could correct that for you.
Yeah, and as you can imagine, these broadcasts have a considerable number of moving parts.
Yes.
Any of which, if they are not working, can
Derail.
materially impair our ability to deliver this to you. So
that's right. So thank you, guys.
Yeah, thanks very much.
I'm going to take some time to type in the questions. We did have a participant contact me after our last broadcast, just as a reminder that the questions that you ask on the Hangout do stay with the course.
Right.
So you want to be careful not to ask us any live questions about real employees doing real things at your real agencies.
Right.
So if you have questions you'd like clarification about some of the issues, we're happy to take those, but we don't want to inadvertently disclose information about employees.
Right.
Once again, on the phone lines, if you would like to ask a question, please press star 1 and record your name.
Let's see. I'm not showing any questions on the Hangout, so maybe we did a very good job of covering.
Maybe we did, or they were bored stiff and bagged out about a half an hour ago.
All right.
I think we also don't have any questions coming through on the phone line.
Okay,
Excellent.
Thank you, Erin, very much.
Well, we're going to go ahead and sign off. But again, thank you very much for joining us. And we look forward to seeing you next month for the Fundamental Series and the Advanced Practitioner Series, and in months in the future, as well as for special broadcasts. So thanks very much for joining us today, Cheryl.
Thank you very much, Patrick.
And thank you all for joining us, and we will see you next time.